What's up, everybody? Thank you for joining me here with a little impromptu live to talk about Sarah Boone's motion for new trial filed by James Owens. Some major issues he found, not just in the trial, but also in the events leading up to trial. Some of them should not be a surprise, but how strong are the arguments presented in this motion for new trial? And does it have any chance at success? We're going to break that down. We're going to answer all your questions today on this live. Make sure you guys hit the like button. Make sure you're subscribed. Let's get into it. All right. So, motion for new trial. This is basically a situation where defense attorneys, when you lose, in order to preserve your arguments, you make this motion for new trial, and the judge is the one who looks at it. So I think that that's an important place to start, that Judge Kranick is going to be the one looking at this motion for new trial. And so as we listen and read these arguments, when we talk about its chances at success, we always have to look to who the person is that's going to be the decision maker, right? When we look at during a trial, it's a jury. During motion hearings, it's a judge. During an appeal, it's an appellate court. But in this situation, for the motion for new trial, it's going to be Judge Kranick. So we'll keep that in mind as we read through these arguments. A lot of people are saying I look more dressed up today than normal. I have a mediation this afternoon that's going to start right after this video ends, basically. And I'm just going from one thing to another. I did vote today. Hopefully you guys all go out there and vote. We don't need to get political in the chat, as it is so divisive, which I think is really unfortunate, and I hope doesn't continue into the future, regardless of who wins. But as we talk about taking pride in doing your civic duty, being on juries, jury selection, things like that with your jury service, voting is the same way. Take it seriously. Vote for what you find most important, the candidate that you think will be best for the country as a whole. All right, let's go into the defendant's motion for a new trial. Comes now the defendant, Sarah Boone, by and through counsel and pursuant to Rule 3.600, Florida Rule of Criminal Procedure, files this motion for new trial, stating in support thereof the following. The defendant was found guilty as charged of second-degree murder on October 25th, 2024. The instant motion is timely filed pursuant to Rule 3.600. The defendant asserts that she's entitled to a new trial under Rule 3.600 on the following grounds. So here are the major arguments listed, right? We're going to go into and dig into each one of these arguments to see exactly which ones have merit and which ones might not. But here they are listed out for us. Number one, the court erred in ruling that the defendant was not entitled to court-appointed counsel. So, number one right there, no surprise. No surprise. We knew she was going to make this argument. Number two, the court erred in denying undersigned counsel's multiple motions for a continuance. Well, there you go again. Another thing that, I am not a fortune teller. I am not a savant of any type. These are obvious arguments that were coming based on what happened pre-trial. So far, the first two arguments that have been made by the defense have nothing to do with the actual trial, which is always interesting on a motion for new trial, but we knew it was coming. Number three, the court erred in failing to grant a new trial when the alleged victim's family caused an emotional outburst in open court in the presence of the jury prior to deliberations. So this was during the closing when the state played the video, the suitcase video, in their first close. He objected to this. He asked for a mistrial. Also not a surprise, but we kind of talked about how strong I thought this argument was at the time. We'll get into it again as we read it here. Number four, the trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, after the state failed to disclose before trial that the witness had formed a new opinion. We remember that. There were major objections. They did a deposition in the middle of court. The judge did as many things as he could to try and cure that problem that the state created in a potential discovery violation. Well, they're saying at this point, that's the reason that Sarah Boone needs a new trial. And then fifth, the state committed prosecutorial misconduct. Buzzwords, by essentially making a second argument instead of a rebuttal argument. So the issue with number five, in my opinion, is I don't remember him objecting and asking for a mistrial over that. You guys can correct me if I'm wrong. It's very easy and possible that I missed an objection during the state's rebuttal because, again, they were so long. Everything felt so long that day. But in order to really preserve this as an argument for appeal, he would have had to object during their second close. Also, they were had up at sidebar. Maybe he did make an objection for improper argument, and this is what he argued up at sidebar, and we just didn't see it. So that's very possible as well. So those are them listed out. We're going to get into them specifically now. Chris K, nice jacket, Peter. Thanks for the distraction today. I need it. Yeah, a lot of people need it. Another thing I want to say, and again, I do not want to talk about politics. It's so hard to have any kind of level-headed conversation about it, which I hate. I'm also not like big into politics. I'm not any expert. But anyways, my one comment is, regardless of who wins, let's try to stay positive and do our best to make society better. Because if everybody does that, then we should be moving in the correct direction, no matter who the president is. We can still appreciate a good-looking married man. Thank you, JSMP Jen, and I'm glad for the name change. And the girl with the animals, thank you so much for joining and gifting a membership. All right, let's get into argument one, okay? The trial court erred in holding the defendant was not entitled to court-appointed counsel. We knew this argument was coming. At the time, I was like, oof, that's a pretty bold move by the judge to say that she has constructively waived her right to counsel. That was a bold move. I said I would have given her one more and then made it as clear as possible on the record, which he did make it clear and he did discuss it beforehand. But from my perspective, we always knew this was going to be an argument until James Owen and crew, right? He had a slew of people there helping him, 2, 3, 4, 5 lawyers / paralegals / legal assistants, all there helping. So that makes this argument much more difficult to move forward on for the defense. And we'll talk about why. In the above styled and numbered case, the defendant had approximately 7 court-appointed attorneys prior to the undersigned counsel taking over, 7, 8, whatever. There were some conflicts off, and so maybe they weren't actually appointed. We don't need to get into the semantics. It's a lot of lawyers. Undersigned counsel took on the above case because he was concerned that Ms. Boone would not have an attorney to represent her at trial. The above case was very complex, even for a seasoned trial attorney who was the public defender of the First Judicial Circuit for years, as well as having a thriving private practice. Almost sounds like he's not talking about himself, but he is. I don't know if I would say it's very complex. It wasn't the simplest case in the world, but it definitely wasn't the most complex case in the world. But here's the problem, right? Whenever you do something like this, and you can even read it in this sentence, right? He's saying, it's so unfair. Sarah Boone was not given a fair shake because you didn't allow her to get court-appointed counsel. So instead, she got the best counsel there is. Former public defender with a thriving private practice. Well, it sounds like we've cured the problem. And you're going to hear that throughout this argument where it's like, was there a problem or was it fixed? It was apparent to the undersigned trial counsel that Ms. Boone would be grossly ill-prepared and unequipped to handle a trial in this matter, or in fact, to handle any other phase of the trial without counsel. Both the Sixth Amendment as well as Rule 3.111, Florida Rules of Criminal Procedure, guarantee an indigent defendant the right to appointed counsel. There appear to be 2 exceptions to this procedure. Number 1, if the defendant physically harms or threatens to harm his or her counsel. And number 2, if the trial court certifies the defendant will not be incarcerated if found guilty, i.e. a judge trial or a bench trial. So what he's saying there is, really, Judge, the only 2 ways that you can ever say that a defendant has constructively waived and therefore take away their right to court-appointed counsel is if they threaten to harm their lawyer, or if you say it's a bench trial and you're not going to send her to jail. So neither of those happened here. Problem with Owens' argument is, number 1, we read a slew of cases in the judge's order that he does have the discretion and the ability and the power to say that she has waived her right to court-appointed counsel. And he laid the record thick. And I would spend probably 15 or 20 more minutes digging into this, discussing these cases, going over again the right to court-appointed counsel and when we can waive it and when we can't, and what the judicial discretion is. But I'm not going to. And the reason why is because James Owens, star private attorney and the public defender of his district, and I agree with him, very seasoned criminal defense attorney, took on the case. Therefore, it is a moot point. And I don't think Kranick has much to consider here. Because whether or not she had the right to court-appointed counsel, she ended up having multiple lawyers, more than would have been appointed for her by the court, there with her every step of the way. And she answered on the record over and over again that she was, in fact, satisfied with their representation and with them as her lawyers. Should the court determine that the defendant is not entitled to court-appointed counsel due to misbehavior on the part of the defendant, the court must follow a process which protects the individual's rights to due process, as well as the defendant's right to the assistance of counsel. In the instant case, undersigned trial counsel would assert that Ms. Boone's behavior did not rise to the level of misconduct to warrant a waiver of the right to court-appointed counsel. And if the court determines that she waived her right to court-appointed counsel, the court failed to warn her or inform her that continued misbehavior would result in a waiver of the right to court-appointed counsel. So here's the positive and negative about this argument as well. He just said there's only two ways and you didn't do either of the ways, Judge. Then he's like, oh, well, there's also this third way, which is the one the judge chose, which was basically in judicial discretion, means the judge's opinion. Did she misbehave so much to waive this right? And Owen said he doesn't think she did. Well, guess what? Just like me, right? If I sit here and I say this judge is wrong or this is what the judge should do, but the judge keeps doing that, if it's a judicial discretion issue, it's up to the judge. They get to, their opinion rules. I can make whatever argument I want. Owens can make whatever argument he wants, but if it's within the judicial discretion, the judges say goes. Now, this last part, I think, would have potentially been the best argument had Owens not jumped on the case. But if Sarah Boone would have had to represent herself and he said you didn't adequately warn her that your misbehavior would result in you waiving your right to counsel, there is some of that on the record. I do think potentially it could have been more clear with one more appointment. And if that appointment would have gone bad, then it would have been a much easier thing to do to pull her right to appointed counsel. But I do think Kranig did make the record. And again, it would be in that wiggle room for a decision for the appellate court had James Owens and team not picked up the case. Under the controlling precedent, failure of the court to appoint trial counsel can result in a motion for new trial being granted. Yeah, but usually not when a full defense team joins the case. Under the controlling precedent, Rule 3.111, Rules of Criminal Procedure, Florida Rules of Criminal Procedure, and the Sixth Amendment, the defendant, through counsel, moves the court for a new trial. So I think that argument number one has somewhere between a 0 and 0.1% chance of getting Sarah Boone a new trial, maybe 0 and 0.001 percent chance of getting Sarah Boone a new trial. So I would not expect that to be a successful argument. Wait, Sarah's not happy with her counsel's performance. She feels she didn't have a good case. So no, that's not what they're saying. They're just saying the fact that, okay, because again, we're going to touch on this a little more in some of the future points, but the fact that the judge said she waived her right to counsel should get her a new trial, period. That's what he's saying. Because in this section 1, he doesn't even argue she was prejudiced, which that's really the only way you ever win one of these. Brianna, yes, I did mention that off the top. Lisa S., thanks for gifting 5 memberships. Let's get to argument 2. The court erred in failing to grant defendant's motion for continuance made by undersigned trial counsel. So no surprise probably here for you guys, but I do want to give a little tip. Show my hand a little bit. This, I think, is potentially the best argument that Sarah Boone has. I said it off the top. I thought the judge would grant a short continuance. The judge did so many things to cure problems that came up, whether it was with counsel, whether it was with an expert, whether it was with a deposition in the middle of trial, or making the other side pay for a deposition if something was late, forcing both sides to work together. He did so many things to try to cure problems throughout the trial. The one thing he did not do was grant any continuance. And I said, a 30 or 60-day continuance, which is what Karen Reed's lawyers are asking for. By the way, I recorded a video on that. I think we're going to play it tonight. It was my plan for today's video because I had this mediation, but I decided to do this over lunch instead. So hit that like button if you guys haven't already for jumping in here over lunch. So the judge did not grant a continuance. And I always thought that this was the best argument the defense had. But let's read it and see what I think might be missing from this argument. Whoops. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for a continuance by the new counsel. So he says this as a fact here, right? Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion. So it's like, oh, you deny a motion to continue, you're going to get a new trial. It's just not, that's like so clearly not how it works. So I think being careful in how you frame an argument can be really important. I also didn't think these were the best cases. They usually stand for other things. But there are cases that do stand for a proposition that a judge denying a motion for continuance can be a reason for a new trial. But this, to me, it says failure of the trial court to grant a continuance will result in a new trial. That I don't agree with. But let's keep reading. In the instant case, when undersigned counsel came on board, the case was 4 years old. Undersigned counsel filed this notice of appearance on August 30th, 2024. This gave counsel 45 days to prepare for a second-degree murder trial. He immediately and aggressively began to prepare for trial. Undersigned counsel did his best to prepare for trial by traveling to Orlando from Milton on multiple occasions, both for meeting with Ms. Boone and attending multiple hearings. Despite his best attempts to prepare for trial, it was impossible to adequately prepare for unforeseen issues arising during the trial. A prime example of this would be reviewing hundreds of pages of texts from Ms. Boone's seized cell phone, viewing all records of prior contact of Ms. Boone and the alleged victim with law enforcement, including inadmissible hearsay by the alleged victim to law enforcement regarding Ms. Boone being the aggressor at times. So he's giving an example that if he would have read all these pages, he would have objected to the inadmissible hearsay by the alleged victim to law enforcement regarding Ms. Boone being the aggressor at times. Counsel, for all purposes, closed his law practice down to prepare for the trial, but due to the short time frame, even with the assistance of other attorneys, was simply logistically unable to be as prepared for the trial as he would have liked to be, and as Ms. Boone is entitled to. Under the controlling cases cited supra, the court's failure to grant undersigned counsel's motion for continuance should result in a new trial. So here's what I'll say. There's a lot of other cases like Callaway or Long that, we've cited in cases before where if a judge, it's very rare actually that a judge does not grant a continuance, especially if there's a legitimate reason, which this seemed to be. But it is, again, an abuse of discretion standard, meaning it's within the judge's discretion whether or not to grant or deny a continuance. So if the judge believes and has reason to believe and documents on the record reason to deny the continuance, usually that's going to be the case. How do you overcome it? Well, you don't overcome it by saying, I did a really good job. You don't overcome it by saying we had all these lawyers working on the case. How you overcome it, which he scratched the surface of, but I don't think dug nearly enough, is you basically have to show that it resulted in extreme prejudice to the defendant. It had to materially prejudice the defendant's case, meaning it had to hurt Sarah Boone's case. And it had to be something serious. It can't be, because of this, we weren't able to go do a take drone footage of the apartment complex to see exactly where everybody was standing during the interview. That would not be material. It has to be something material to the case. And I would argue he started. Ms. Boone, somebody saying Ms. Boone was the aggressor at times, he believes should have been limited out. That would potentially be material, but probably not on its own. So here's what I would have liked to see. I would have liked to see more cases cited and another paragraph of exactly how Sarah Boone was prejudiced in this case. Because if he can argue that because of the motion to continue, and I'll tell you, some of these cases literally stand for, I wasn't able to get an alibi witness, or I wasn't able to locate certain witnesses that I would have if I would have had more time. And we know that there were some witnesses at the apartment complex or in the past that they were trying to contact, they were trying to get a hold of, and they didn't because of the time constraints. And because of that, we were not able to present the defense that we wanted to because we didn't have time to talk to all those witnesses. We believe these witnesses would have testified to X, Y, and Z. Because we weren't able to do that, it prejudiced Sarah Boone's case. And I would have gone through now and read all those hundreds of pages of text messages and everything from her phone and say, Judge, here's a text message we would have entered. Here's one we would have kept out. Look at how bad this is. And this is not admissible, but we weren't able to get to it because we just didn't have enough time. And that materially prejudiced her case. So if you have a list of 5 or 10 things that really crushed Sarah Boone's case, again, can't just be bad facts. It has to be bad facts that more time would have solved, that a continuance would have solved. And if more time would have solved something that became a major problem with Sarah Boone's case, That's actually a very good, and in the past has been a winning argument for a new trial. But I don't think there's nearly enough here in this motion. I don't think there's nearly enough prejudice shown in this motion for the judge to believe that it's an abuse of discretion. I'll also say Kranik's a very smart guy. He already considered all this when he denied the continuance. So there's a 0% chance this is going to win at this level. But I do think that this is their strongest argument. I'd put it in a 0 to 5% chance that this is enough to get him a new trial on appeal. Not going to win at the new trial motion level, but maybe the next one. Peter, I think you do an excellent job of demonstrating ways people can make a difference in politics. You are very involved in the trial lawyers groups where you can craft things in Florida. Everyone can be involved in the city, county, and state level. Yes, I agree. And guess what? My favorite thing to do in politics is do things that are on both party lines, both sides, right? Be like, listen, why would you disagree with this? Why would you disagree with that? Because I truly believe we all really agree on more than we disagree on, but the media and everybody that wants to, really puff everything up focuses on the things we disagree on. But yes, a lot of the 99% of the stuff I do is bipartisan, right? Rules to make things better, safer, cleaner, faster, easier, better for the people of the state, right? So thank you so much for this pesky pirouette. And I agree. That's politics to me, is what we can do to help people in our communities. That's how I think of politics. All right. Next argument. Argument 3. The court erred when it denied a motion for new trial due to the emotional outburst in the presence of the jury. Prior to jury deliberations, the alleged victim's family members began to audibly and visibly get upset and departed the courtroom. Undersigned counsel timely moved for a mistrial. I agree with him there, requesting a new trial. The court did not give any curative instructions or address whether the outburst could adversely affect the jury's deliberation. Florida appellate courts have held that failure of the courts to grant a curative instruction or a mistrial can result in the necessity of a new trial. The court is unable to determine if the outburst affected the jury's decision to make, or because no inquiry was made. Under controlling precedent, the defense is entitled to a new trial. So here's what I'll say here. Number 1, I don't really remember. I have not gone back and checked. You guys can do that easily and let me know. But I don't remember that he asked for a specific curative instruction. And if he did, what would it have been? Because all it really would have done is highlighted the fact that the victim's family stood up and walked out, right? Don't you think? So I don't remember what curative instruction exactly he asked for. That's to start. Number 2, I just don't think it rose to the level to grant a new trial. So again, I'll put this one in 0 to 0.1% chance of winning here. And this is one, if I'm writing an appeal, I probably don't think is a good enough argument to put on appeal. So far, I've only found one that I would put on there. All right. Argument 4. The court erred in allowing the opinion of the state's expert not previously disclosed. The trial court failed to disallow the opinion testimony of the state's rebuttal expert witness, Dr. Tanya Werner, MD, after the state failed to disclose before trial that the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. This issue was discussed extensively in the expert's deposition taken on October 4th. The state committed prosecutorial misconduct by failing to disclose this new opinion as agreed in the deposition mentioned above. I don't know why he didn't cite the deposition. I probably would have done that. In addition, the state's expert opinion on whether the defendant perceived an imminent threat necessary for justifiable use of force and battered spouse syndrome testified to before the jury was improper. The state's expert, Dr. Tanya Werner, admitted she had not listed the defendant's testimony before the jury before forming her opinion on this. Listened to the defendant's testimony before the jury before forming her opinion on the ultimate issue of fact. In addition, Dr. Werner failed to listen to the testimony of Dr. Michael Brandon and Dr. Julie Harper before expressing her opinion. That is not like an appealable issue. That's just like maybe not the best expert work, but that section is not an appealable issue as far as what she listened to. Now, the fact that she's testifying to the ultimate issue, as you know from our discussion in the trial, might be a good argument. Furthermore, the state's expert testimony on this issue of whether the defendant perceived an imminent threat at the time of the event violates the province of the jury. Witnesses are prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury determine what occurred. When a witness is asked to express an opinion that applies a legal standard set of facts, the opinion testimony is generally inadmissible. Section 9703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. The testimony may interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. Okay? So this is basically his argument saying, A, this expert should not have been able to testify to the ultimate issue, which, she was able to testify to in this case. Now, I think there's a good argument that that testimony was improper. The question is, how material was it? How big of a deal was it? How much was it highlighted? Was it enough within her expert testimony that based on applying the psychiatric principles, how somebody would reasonably react to fear of imminent danger or harm? I think potentially there's an argument there. And again, it comes down to judicial discretion. And this is another one that I think is probably the second best argument he has, but much less of a good argument when compared to the denial of the motion to continue. Because, for a couple of reasons. Number one, I think the judge did cure part of this problem. The undisclosed opinion the judge cured by allowing Mr. Owens to take a deposition during trial. It sucks. It's not the best. It's not how it should be. But I think the judge probably did enough to cure this issue. Number two, I thought the state did a good job not highlighting it and repeating it over and over again in closing. If they would have really held on to it and said, even this expert said she wasn't in imminent fear. How are you going to disagree with this expert? If they would have made arguments like that, they probably still would have won, but it would have made this much more damning. Instead, I think they barely mentioned it, if at all, the specific issue that Owens is dealing with here, her testifying to the ultimate issue in the case. So good job by the state to not highlight it, not make it a huge issue, knowing it was going to be an appellate issue later. Nick said, does she have the right to court-appointed appeal counsel? Yes. Or does the judicial waiver from before still count as she's waived the right to counsel? So I'm going to be completely honest with you. I have never seen before this case a judge say that somebody has constructively waived the right to counsel. I do not think it should, nor do I think it will apply to appellate counsel. I hope it does not, but I can't answer you with complete certainty. Christina, Peter, is it normal for attorneys to move for a new trial post-conviction, or is this becoming a relatively new trend? It is completely 100% normal. Lawyers do this in every case. Basically, you pick your best arguments, you throw them down as quick as you can, and you get this initial one out there. It's going to get denied, and then you start working on the appeal. But these are part of the appellate steps as you go forward. All right. Gringa, Peter, does the standard of legal error that could have affected the outcome apply at this level? So yes and no. It's got to be an abuse of discretion. It's got to be material. But this is usually an appellate standard that it affected the outcome of the case. You have to prove it affected the outcome of the case. But this is always an overarching theme in criminal appeals. Always an overarching theme in criminal appeals. Thank you, Lisa, for gifting more memberships. All right, let's take a look at the last argument here. The prosecutor committed misconduct by using rebuttal argument to make a second closing argument. The state committed prosecutorial misconduct. Again, pretty serious allegations. By essentially making a second closing argument instead of a rebuttal argument. Counsel for the state made a second closing argument posed as a rebuttal. So what he's arguing here is that what's supposed to happen is the state gives their closing argument. And then the defense responds. They respond to what the state said, and they make their own closing argument. And then the state responds to the defense's closing. It's kind of like a redirect. You do the direct examination, the defense crosses. Your redirect has to be limited to what came out on cross. So what he's saying is, instead of doing that, they just kind of went rogue and re-argued the case again and argued everything they wanted to argue. So here is the issue with this argument. Number one, it's very rare that something like this would be something that would overturn or give a new trial. Number one. Number two, because a defense attorney's argument is a response to the state and their own closing argument, it's really difficult to limit the state, because if he's arguing she's not guilty, right? I mean, you can craft an argument. You could see even non-lawyers, right? You guys are really smart. You can see that if I get up there and say she is not guilty of this crime, and you are going to respond to that in trying to prove that she is guilty, what is it you're not allowed to argue? Right? Judge, he said she's not guilty. We are now going to argue she is guilty in response to that. Additionally, what you don't see here is any citations or quotes. And while they don't have the transcripts yet for the trial, I can almost guarantee he could go back and listen. What did Mr. J say in rebuttal that was outside the scope of defense's closing argument? And from my perspective, he would be really hard pressed for a lawyer not to find something he was responding to. Sarah was in fear. She didn't mean to. He was the aggressor. She was not. She was the victim. She didn't do this the way they said she did this. Anything that you're going to bring forth as evidence as the state is going to be in response to rebut that closing argument made by the defense. Do you get what I'm saying? Is that confusing? It's in my head, it feels so simplistic to say when you make your entire closing argument, it's really hard to say they can't make an argument in response to that. It's not the same as just one witness. Like this question, judge, has nothing to do with this witness, or we didn't talk about that at all. Why is he asking this on redirect? Because most cross-examinations are not using the witness as your own. You're just responding to what the other side did. Some of them you are. Dreamcatcher, Peter, considering Owens flat out refused anything to do with her new trial, why is he asking for a new one for her? So lawyers are just, one of the things lawyers always do, right? And we have to do is protect the client's rights. If he didn't do stuff like this, he could be committing malpractice. Even if he's not going to try the second case, she doesn't have a lawyer. So theoretically she could do it herself, I guess. But if he knows you have to do this within the time period and fails to do it while he's still representing her, he said he was going to represent her through the initial post-conviction and all the way through the sentencing. So if he's going to do that, he has to protect her rights and protect the record with a motion like this. And maybe that's all it is. Maybe that's all it is. Is there ever a trial that isn't appealed? That's a good question. So lots of trials are not appealed because some kind of agreement is made afterwards. Like if you don't appeal, we'll give you this. If you don't appeal, you'll do that. So yeah, a lot of them aren't, but just flat out, I don't want to appeal. Maybe if she would have lost and got manslaughter 2 years, maybe she didn't appeal, but most are appealed. Michael, so Mr. Owens is complaining that the prosecution went rogue by rebutting the story of Sarah that he was painting in his closing. I mean, when you paint it like that, it's not much of an argument, but I don't think that's what he's saying. I think he's saying they basically repeated a bunch of their argument and did another closing, when in reality, you're not limited in your time. You can split it evenly first and second close. So this is just, it's never really going to be a winning argument. What is he trying to accomplish with this effort? Protecting her rights, right? Protecting her appellate arguments, making a record, making the judge make a call, presenting the issues he saw that happened in the first case. Does the quick jury deliberation ever weigh into the new trial decisions? As in, this is all potentially a moot point. Also, hi from the UK. Does the quick jury? So no, how quick or slow the jury deliberations are, well, that's not true. Defense attorneys will sometimes use the fact that it took 5 days to convict, or that they came back once and were hung. Defense attorneys will often use that. State attorneys will very rarely argue, it was such a quick verdict, judge, it was obvious, right? Because sometimes that can just mean the misconduct was so bad and so prejudicial that this jury was never going to think another way. Now, I have read it in certain appellate decisions that courts will say it was so quick, there wasn't a confusion, but he didn't make an argument that the jury was confused or didn't know what they were doing. You know, it depends on what the argument is and what the response is to ever get into a discussion like this. So one other thing I wanted to mention on what I think is their best argument, which is the denial of the motion to continue, is Kranick also protected the record on that. We saw every instance. Are you satisfied with what your lawyer's doing? Yes. And they ended up saying, hey, we have these other witnesses. We're not going to call them. There are even some witnesses that Sarah Boone wants us to call. We're not going to call them, judge. And we just want to confirm on the record that's okay with Sarah Boone. And what did they do? They confirmed on the record that that was okay with Sarah Boone. So what does that do? That makes some of your continuance arguments null and void. If you decided not to call them, then how is it prejudicial that you weren't able to call them? Now, that's why I would have listed all of the reasons that the continuance screwed up the case. All of the ways Sarah Boone was materially prejudiced because of that continuance. I would have listed as many as I could possibly get at this point. We don't have the transcript. but everything that you couldn't do that you would have been able to do if he would have given you 30 or 60 days. That to me would have been the best argument and the most appropriate part and place to do that would have been in this motion for new trial. All right. I am going to get to eat a little bit before my mediation, but I want to come on here, break that down with you. Make sure you hit the like button. Make sure you subscribe and hit the reminder bell because we do have that Karen Reed video coming out tonight, which I actually thought was much more interesting than I expected before I read it because I hadn't really read it myself. But all of the new information and how different the second trial really might be, we start to get a little hint of that in that motion continue with the affidavit from the prosecutor. So make sure you guys check that one out. Everybody get out and vote today and be nice to your neighbor, regardless of who they vote for. But I appreciate you guys all joining me. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.